Okay, we do have an awful lot to cover off today, so even though there are lots of people joining, we're going to make a start. If you could just do me a favour, and in the panel for the GoToMeeting software, just raise a hand to show us that you can hear us okay. Perfect, I can see hands being raised, so that's great. Okay, so this webinar today is on SMS and GDPR and what you need to know to be compliant. My name is Liz Wilson, I'm our Head of Marketing, and I'm joined by Iain Collison, who is our Compliance Officer.
Good afternoon.
One thing this is the most popular webinar we've ever done by some considerable margin. And what we've had to do, we've made a decision to do, is not take Q&A during the live recording. So if you have any questions, please do write them into the panel. However, what we'll do is we'll collate them after the webinar has finished. Ian and I will answer them, we'll anonymise them, and then when we send out the slides and the recording to the webinar, we'll distribute that Q&A transcript as well. So I apologise for that, it's just with the number of people on the call, we thought it might be impractical to answer questions. The other thing I need to flag up is that while Ian and I are both very well informed on this subject, neither of us are lawyers, and this is not legal counsel. This is advice, and if you do want legal counsel, you should speak to a lawyer. And the final bit of housekeeping is that it's worth mentioning that most of this presentation is aimed at non-public sector companies. So I did try to exclude the invitation so that it didn't go to public sector companies. If you are in that sector, the bit that won't be totally relevant to you is when we're talking about the legal basis for communication. So at that point, you can take a break and come back to it when we move on to privacy policies. So without further ado, the agenda we're going to be covering off today is up on the screen now. We're going to be doing a brief introduction to what GDPR is. And before I forget, there's a poll, and I've not done one of these before, so hopefully this works. I'm going to launch a poll which asks you to say what your current level of confidence in your GDPR compliance is. So if you can see that up on screen and you can vote for us, it will give us a good idea of the kind of level of knowledge within the room right now. And with, oh goodness, this is fantastic, it's working really well. So with 79% or 81% of the vote, we've got 57% of people saying they're somewhere in the middle, 27% of people saying they're not confident, and 16% of people saying they're confident. That's absolutely fine. Today, we're hoping by the end of this that you will feel more confident. We're going to look at customers, prospects, and ex-customers. We're going to look at the lawful basis for communicating with these guys. We're going to move on to privacy policies and notices, onto data processing, and then use Esendex as the case study for this. The Esendex part kind of pulls those three previous sections together and puts them all in context. So while at the time it might seem a little bitty, at the point at which we talk through the Esendex process, it'll all come together, we hope. So, an introduction to GDPR, and over to Ian.
Thank you, Liz. Okay, so we're going to go through a few of the key points of GDPR, some of the big changes. I'll go around the circle. The enhanced rights for individuals. So the aim of this change is to put the individuals in control of the data they decide to share with organisations. So some of these enhancements to existing rights include subject access requests. They will now be free of charge and must be handled within 1 calendar month rather than 40 calendar days. Data subjects will also be able to request that their data is deleted if they object to processing under their right to be forgotten and erasure. And it also places obligations on organisations to maintain accurate records and only collect the data that is necessary for the processing purpose. So the next one there is explicit and informed consent. So currently, this is the most commonly used, or one of the most commonly used lawful basis for processing. The bar's been raised considerably to obtain valid consent under the GDPR. And organisations that use consent as their lawful basis of processing must record explicit consent for each of their processing activities. Blanket consent, hidden pre-tick boxes in privacy policies will no longer be compliant. Privacy by design and default. Organisations should consider how their processing may affect the privacy of individuals before they start to do so. Data mapping and conducting data life cycles can help to establish whether it will have an impact on privacy, as will establishing your lawful basis of processing. Increased transparency. Your processing notices and or policies will have to be granular in their detail of your processing activities. So individuals need to know what you're doing with their data effectively, why you're doing it, how you store it, how you protect it, who you share it with, and how long you're going to keep it for. And you also need to maintain records of your processing activities to show accountability. That's a new principle under the GDPR. Privacy impact assessments. Part of adopting the privacy by design and default is conducting privacy impact or data protection impact assessments, as they're known in the GDPR, where it's applicable. So the ICO has produced extensive guidance in the form of a code of practice on this issue for privacy impact assessments, and it includes a set of screening questions to test whether an assessment is needed for you and your processing activities. And finally, increased sanctions. So this is the one that everybody's talking about. You can get fined a hell of a lot more for getting it wrong under GDPR than you can under the current Data Protection Act. So the fines are divided into two bands, the first of which is up to 2% of your global annual turnover, or 10 million euros. This could be applied for minor issues like not having your documentation up in place or up to date. And this goes up to 4% of your global annual turnover, or 20 million euros. So in both cases, it's whichever is greater. And this is for more serious issues like having a data breach or willfully processing data without a lawful basis.
So that part was just to scare the living daylights out of everybody. We'll go through these areas, the ones that specifically pertain to sending SMS now, in more detail. So we're now going to move on to customers, prospects, and ex-customers. And what I want to sort of lay the ground out right now is to say that there are actually 6 lawful bases for communicating with customers post GDPR. And if you are sending what we would term transactional SMS, which is to say things like delivery notifications, server outage alerts, maybe staff scheduling, what we would term kind of essential business critical messages, the lawful basis for sending these messages is likely to be the performing of a contract. So go ahead and go take a look at the lawful basis for sending absolutely necessary information like that. The next few slides, we're going to look at what you need to do from a marketing perspective. So if you want to send messages to customers and prospects and ex-customers that aren't strictly necessary, that don't fall under what we would call a transactional SMS basis. So we need to define first customers, prospects, and ex-customers. Customers, you need to be able to prove that you have an existing customer relationship, and it's not quite as clear-cut as it sounds. For example, and I'm going to steal this analogy from Iain, if you're an insurance provider and once a year you issue insurance to somebody, it's quite reasonable to say that a year later, and with no interaction with that customer, they're still a customer. You sold them an annual service. Whereas if you sold somebody something that was on a monthly subscription and they cancelled, and 6 months later, you could probably no longer justify saying that they were an active customer. So the time at which somebody moves from being an active customer to an ex-customer is going to be specific to your business model. But you will need to have made that distinction, be able to document and justify the distinction between a customer and ex-customer, because your rights when it comes to communicating with them are quite different, as we'll move on to in a moment. And prospects, more simply, are people who may have inquired about your products and services. You may have met them at an event. They may have signed up for your email newsletter. They may be a purchase mailing list, but they've never actually purchased from you. And as you can see from the column on the left, we look at legitimate interests as the lawful basis for communicating with customers, but consent for prospects and ex-customers. So let's dig into that in a bit more detail. So this is when I started looking at GDPR, I was really worried that we were going to have to go through a process of contacting all of our existing customers and saying, do you want to hear from us, which sounded both painful and also would probably lead to us having a much smaller customer database. Fortunately, for us, and I think for probably a lot of people on the call, legitimate interests is Iain doesn't like me to use the word better. Valid form of lawful basis for communicating with these customers and storing their data. It's very flexible, as you can see from the definition at the top of the screen. It just means they could reasonably expect to be communicated with. There's a minimal privacy impact, and there's a compelling justification. However, that comes with both flexibility. It's also the most easy to challenge by the customer because it's not as clean cut as I opted in. So in order to make sure that you're protected against customer challenges, you need to do a legitimate interest assessment. 3 simple questions. Do you have a legitimate interest reason for sending this message? Do you need to send it in order to achieve those interests? And have you balanced that against the individual's interest, rights and freedoms? And at the bottom of the slide, which we'll share after the presentation, is a link through to an excellent PDF document which gives you a framework for asking those questions in a methodical way. But the really key takeaway point from this particular slide is that from an existing customer relationship, you do not need to go and request consent to communicate with them. But the situation is different for prospects and ex-customers. If you can't establish an existing customer relationship, you will have to, in most cases, establish that you have consent or gain consent. And this is harder than it used to be.
So anything other than explicit consent specific to your processing activities should be reviewed. Even if you believe that you've got adequate consent, it will degrade over time, as we touched upon previously. This will depend on the purpose for which consent was gained. And if you do rely on consent, take the opportunity to refresh any valid consent that you hold to ensure that it's ready for the new rules when they do come in. If you're in doubt over whether your consent is valid, then you can send your communications via letter over the post, as they're not subject to the same rules around consent that SMS and email are.
And we will go into that in a little bit more detail. But broadly speaking, consent is, as we can see in these examples, quite specific and needs to be there at the point at which you are gathering the information. So there's 2 examples on screen, neither of which are perfect, which is why I've tried to very poorly anonymize them. The one on the left is great in that it gives you the options for the different channels through which you would like to be contacted, but doesn't say specifically what content you could expect to receive. The one on the right says explicitly what contact you'd want to receive, but doesn't give you the option to pick your channel. There's another method, there's another approach to this, which is the one that Esendex will be taking, which is to say, please opt in to receive marketing messages from us. And then in the next message, they will get a link to a preference center, which then allows them to go more granular. And we've got some examples of preference centers on the screen now. So preference centers are a web page which allows people to say explicitly what content they want to receive through which channel. The example on the left is a mobile version. The example on the right is the new Esendex Communication Preference Manager, which we launch in the next couple of days. This isn't a legal requirement, but it is very much meeting and exceeding the requirements of the GDPR recommendation for granularity over consent.
Yeah, it's fundamentally putting the control of your data back in the data subject's hands.
And the other thing that was mentioned in the guidance is that regarding consent is that consent must be possible to withdraw as easily as it's given. So every email or text message you send out, which is marketing orientated, needs to have an opt-out. 2 options for most countries. You can either use a text a keyword to a shortcode, as the examples on the screen show, or you could provide a link to your preference center within your text message or within your email, of course. But what about your existing database? And this is, of course, because what we've just been touching on is how you would approach somebody signing up for your service today. Your existing database, what you'll have probably seen a lot of is what people are calling repermissioning emails, which is to say, you signed up to hear from us, but we'd like you to reconfirm that consent. And you can see some examples here from The Guardian and from Cycle Scheme. This is not a bad idea at all. And Ian, you were saying you got one last night with a great incentive.
Yeah, it's completely fine to incentivize people to sign back up or reconfirm, repermission, however you want to phrase it. An unnamed music shop was offering me a very expensive pair of headphones as a potential prize in a draw if I repermissioned with them. So I obviously accepted.
Yep. So this is an exercise that Esendex will be going through as well, of contacting our prospects and lapsed customers to say, would you like to hear from us going forward? And if they don't respond to those series of emails, we will actually then post GDPR, we won't be communicating with them anymore. So in some ways, yes, you may end up with a smaller database, but in other ways, you're going to end up in a much more engaged database, which is no bad thing. And nor do you have to rely on email, even mobile first emails for this purpose. An example on screen is how text messages are being used to send people to a preference center. This particular preference center was built using our Mobile Journeys web app. So you just send a personalized link to the customer. They can either validate themselves on screen and then choose their particular preferences. So you're not entirely reliant on email. And if you've got more mobile numbers than email, or you want to try a multi-channel approach to getting subscribers, then this is a great way to go about it. However, there is something that you do need to be mindful of a couple of things. In the UK, it's the PECR, which stands for
Privacy and Electronic Communications Regulations.
That, and in Ireland, it's the Data Protection Commissioner. Both these two legislative bits of bodies go alongside GDPR and specifically handle electronic communication, which includes SMS and includes email. They will be eventually superseded by the e-privacy regulation, but that's not valid yet. So right now, these are the two pieces of legislation that our UK and Irish customers need to be mindful of. And the point is that you can only do a repermissioning exercise if you collected the prospect data in a legitimate way to begin with. So and a soft opt-in is fine. If they were a prospect, they inquired about a service, you met them at an event, that's absolutely fine. If you are unsure whether your list meets any of this criteria, as Ian alluded to earlier, the safest thing is to do a mailing campaign rather than an electronic campaign, because post campaigns are not governed by as strict criteria. They're not seen as intrusive, or indeed, frankly, as effective as an electronic campaign would be. The cases of Honda and Flybe are a bit of a cautionary tale. In the case of Flybe, they sent an email to people who had actively unsubscribed, asking them to resubscribe, which is quite clearly not compliant. And in the case of Honda, it's a little bit more woolly. They sent an email asking people to confirm their subscription, but they couldn't prove that they'd ever collected the data in a legitimate way to start with. So they were both fined by the Information Commissioner's Office.
This is also particularly important if you are buying in marketing lists, you rely on data warehousing. It's very unlikely, given the high bar for consent and how explicit it needs to be, that we will see the continuation of this kind of activity or companies selling data on to third parties with implied consent.
One more thing I should add here, and it's not on the screen, but the Irish legislation goes one step further than the UK legislation, and it says that the sale must have occurred not more than 12 months prior to the communication going out. So you can text somebody 6 months, 11 months after their purchase, and if they don't opt out at that point, it's considered to be an opt-in, but you can't have no communication with a customer and send them a text 13 months after their purchase. That's not compliant in Ireland. And to be fair, I can't imagine many scenarios where you would wait 13 months to contact a customer, but it's worth mentioning. So we're going to move on now to privacy policies and notices. The difference between the two is pretty semantic. A policy is usually the more detailed version of the document, and the notice being the sort of stripped down, slightly more user-friendly version. Ian says they're completely interchangeable in terms of terminology.
Dependent on content.
So we'll take Ian's word for it. Warning about this slide. I appreciate it's really busy. It's because we're going to issue this slide deck after the presentation, and I found this particular diagram really useful when I was reading up on the subject. I don't expect you to take it in as part of this presentation, but when the slide deck comes around, it's worth having a look at it because it places the privacy policy and notice in context of the broader organisation and the data flow. So on to updating your privacy policy, and this has been Iain's life for the last few months.
Yeah, so the first thing that you need to do is you need to understand the data that you hold. So an audit of the data, the personally identifiable data that comes into your organisation, where it sits, where it flows, who you share it with, how you protect it, and how you delete it. This is an example of the approach that we took to what we refer to as a data lifecycle exercise. That would be the first stage. Secondly, you should complete the screening questions for a privacy impact assessment to see if one is applicable for your processing activities. And then the third part of it is actually writing it. So your policy should detail what information you're collecting, who the policy applies to. So for example, our privacy policy applies to you as our customers and us as the data controller, not to the information you share with us for sending messages. The type or categories of personal data you're collecting and processing, the third parties that you share the data with, and they should be named in the policy, and their own privacy policies should be linked from your own. How you protect the data that you hold and where you hold it, so it's particularly important if it's kept outside of the EU or any of your suppliers are keeping it outside of the EU. How you dispose of the data once you no longer process it, and how concerns about your processing can be raised with both you and the relevant data protection authority.
And so this is basically how you write a privacy policy. And in terms of how you then present it to customers, we're just going to look at a few examples here. This particular methodology is called the just-in-time approach. When you're completing a form on a website or on a mobile device, a message pops up at the point of completing the field to say, this is why we need this data, this is what it's going to be used for, this is who it's going to be shared with. Nice light touch way, and it does cover you from a GDPR perspective. Another approach to this, slightly lower tech, is the layered approach, which is to say you give people the key information they need about how the data will be managed and provide a link to further information, and both are absolutely fine. Hopefully that makes sense. A more detailed privacy notice, and this is an example provided by the Information Commissioner's Office. They provide this as a good example, largely because of the areas I've highlighted in blue. It's written in plain English. It explains what the notice is about. It says what the data is going to be used for, who it's going to be shared with, who it won't be used for by, and who you can contact if you have any questions about it, and doesn't make that process difficult at all. Okay, so that's privacy policies. Again, I realise we're rattling through, but the slide deck will make a lot more sense when you've had time to digest it, I feel. Data processing. So, as a so there are two people on the hook for GDPR, data controllers and data processors. And you are a data controller. Everybody listening into this call is almost certainly a data controller. If you collect information about a living person, you are a data controller. A data processor is someone who takes your data and, following your instructions, does something with it. Now, Esendex is an obvious one. You send us your customer or staff data and we send text messages out on your behalf. However, it goes much further than this. The provider of your CRM system, your billing system, any cloud hosting services you use, Google Analytics is a data processor, any outsourced IT or contact center services. These are all data processors because they touch your data in some way.
This is why your data mapping exercises are critical as well.
So what are your responsibilities as a data controller? And the first one is to identify who your data processors are. So this will go through, as Iain said, a data mapping process, which forms part of that privacy policy we touched on. You go through and you look at every part of your business and say, where am I touching customer data? What systems are touching that customer data? And identify all the data processors in play. Then you need to ensure that the data processors have sufficient guarantees that they meet the requirements of GDPR. I've got a link at the bottom of the page to a series of questions that you can ask your data processor. You need to ensure that a data processing agreement exists between your company and each data processor, and we'll talk about this in a bit more detail later on. You need to ensure that data subjects can exercise their rights. That hyperlink goes through to a really nice infographic which just explains in really clear detail what rights they have and how they've changed from previous legislation, and that where appropriate you can demonstrate that you've received consent to store and process their data. Ensure that the processing, and by processing, it means, it's very broad, it means the storage and any use of the data, is limited to the purpose for which the data was collected, and you're only collecting what you need, which is a process called data minimization. And finally, as a data controller, you need to be in a position to notify the supervisory authority in the case of any data breaches within 72 hours. So on to a data processor's responsibilities. And I'm going to leave these up on screen because there's something I want to ask Iain while these are kind of being digested. In the case of Esendex, Esendex is both the data controller, I figure, because we have customers, we collect their customer data and we determine what we're going to do with that customer data. Yep. But we are also a data processor because we take customers' data and we, on their behalf, and we don't own that data, but we process it following their instructions. So are there any other scenarios where people might be both a controller and a processor?
If you determine the how and why of the data, so if you're a data controller, then you could also process that data. But generally, if you're employed as a data processor, you will only ever be the processor for the data that you're contracted to use. So
the important distinction there is that somebody acting solely as a processor is acting solely on instructions from a controller, whereas a controller issues those instructions and has that contract with the processor. Happy? Perfect. And so the next part of the presentation, hopefully we're going to bring all of this information together and put it into a bit of context to look at how Esendex is on the path to GDPR compliance as a controller. So we're putting ourselves in your shoes as a retailer of some description, and I'm going to talk to Iain about the steps we've taken to become compliant. Starting with, how do you start? If you haven't started, where do you start?
So the first stage of the process was the data mapping exercise to ensure that we understood where the data was, how it flowed through Esendex. From the initial transfer of data to Esendex, through to the storage, access, sharing, and ultimately the disposal of the data. So once we understood where the data was flowing through the environment, we can make decisions on how to improve processes and procedures. And then after that, we reviewed our own lawful basis for processing data. So we don't rely on consent to process any of your data. We act on a lawful basis that is the performance of the contract between you and us. The rest of our processing as a controller is based on our legitimate interests, which range from the effective management of our business and website right through to the proper protection of the business against risks. So we're currently in the process of finalising our policies for publication. The first one that's going to be going out is our privacy policy for the data that we collect from you and process to provide a service to you. It's important to note that this policy does not apply to the end user data that you transfer to us for communications purposes. We've created a separate data processing agreement for this purpose, which sets out how we will handle and protect your customers' information. And if you want a copy of this data processing agreement for review, then you can contact your account manager.
So the next question comes from me as a marketer who is not particularly technical. I understand as a data controller that I am responsible for having contracts or agreements with every data processor. What I'm not completely clear on is who is responsible for those agreements. Should I be issuing them to Google Analytics? Should I be issuing them to Esendex? Should I be issuing them to my CRM system? Or will they come to me with that data, with those agreements?
Largely depends on how GDPR aware your supplier or customer is. So we're in the process of sending out data processing agreements to both suppliers and customers. Some of our suppliers, for example, Google, have already sent their own data processing agreement out to us. So we're making sure that some form of agreement is in place ahead of GDPR with all suppliers and customers.
And in the event that you've not received this from your data processor,
it's important to get one in place. It is a requirement of GDPR specifically that if you engage with a processor, you have a contract in place that details the technical and organizational measures that they are carrying out to protect your information.
Okay, perfect, thank you. And so going back to the original topic of discussion, which was how we've approached GDPR, who is responsible for that massive data mapping exercise? Because it's clearly the foundation that underpins the whole process.
Yeah, it's been carried out by the entire business, so it's quite a complex process, and it's not really something that can be carried out by a single team. So we have had oversight of the entire process, and we've kind of coordinated all of the inputs, but we've had fantastic support from other areas of the business, and it's been a real team effort across the organisation.
And what's been the hardest part of this whole process?
I would say that the most difficult part is dealing with the unknown elements of GDPR. So we're trying to understand something that's not yet been put into place or been used or exercised. So with legislation and regulation, examples of how it's used in the past give you an indication as to how you could fall foul of it. And they also provide the basis of guidance that are issued by authorities to help you remain compliant. We don't have a lot of that at the moment because it's not been put into effect. So that's definitely been the most challenging part. And in terms of both internal and external stakeholders, what's the sort of communication approach once the bulk of the work's been done? What do you do about? So the first thing that is going to go out will be our privacy policy. As I said, we've gone for a dual privacy policy approach. So you will have on the left-hand side the sort of synopsis or summary in plain English, and then on the right will be the more detailed explanation of the policy. Once we've updated this, we'll be letting customers know that it is there and they should read it, and we'll also be sharing it with staff prior to its publication. We're also rolling out, as we touched upon, our updated communications preference manager, so you can manage your own preferences on how we contact you and what we contact you about. And then finally, all staff have been enrolled on a GDPR training program, which is delivered via our online training portal. Covers multiple aspects of GDPR, so the key changes, differences between data processor and controller, that sort of thing. And from a marketing perspective, as I touched on earlier, we are also going through the recommissioning exercise for prospects and lapsed customers while we have the opportunity. Very nearly the last question. How have we managed the relationship with our data processors? So again, putting ourselves in our customer's shoes, what the steps do they need to take to ensure that they've got those agreements in place? So we're currently in the process of obtaining either signed versions of our own data processing agreement from our data processors or sub-processors, or we are reviewing the data processing agreements that they have sent through to us.
And because I know it will be important to people on this call, everyone on the call is a customer of Esendex. How is Esendex behaving as a data processor for our customer base?
So our role as a data controller, even though we've spent the majority of our time talking about it, is quite small in the total makeup of the data that we hold or that flows through us. So for the large part, we're a data processor for the information you transfer to us for communications transmission. We are certified to ISO 27001 standards, which go beyond the GDPR's requirement for a privacy information management system, and we're externally audited to that standard each year to To ensure that we're maintaining our robust governance system, this covers all aspects of data protection and information security. And as we've said several times now, we also have our data processing agreement, which gives full details of our technical and organisational measures and how we will protect the data you transfer to us.
Perfect, thank you, Iain. So in summary, we've just collated some of the information into a single slide deck here. To prepare, it would be smart, even in a smaller organisation, to make someone responsible for this. In our case, we're very blessed to have Iain. You need to take an inventory, do that data mapping exercise of the personal data that you hold and with whom it's shared. You must identify your data processors. It's very likely that there will be multiple legal bases for contacting customers. As we alluded to at the very start of the presentation, transactional SMS of the sort that's business critical will likely fall under the fulfillment of a contract. If you want to market to your customers, it will fall under legitimate interests, most likely. If you are a public sector organisation, you have your own lawful basis that's specific to the public sector. And if you want to market to prospects, then you must gain consent. Going through the review column, you need to look at whether your personal data is adequately protected and secure, whether you have the procedures in place to detect and report any breaches. Go through your privacy notices, update them where necessary. Esendex is going through that process now. You need to review how you obtain and record consent. You need to be able to produce proof of this if you're asked for it. So it's probably not the best idea to have a sort of filing cabinet full of paper tick boxes, although that would be adequate as long as you could produce it on demand. And you need to review that you are able to comply with individuals' data rights and make sure you are familiar with the individual's data rights. And the steps you need to take, I'm going to ask Iain to explain this first one, to create a data privacy governance structure. I can't even say it. Can you just explain that for me slightly?
Yeah, so this is all of the documentation that you accrue through becoming compliant with the GDPR. So your data maps and your lifecycle documentation, all of your data protection and retention related policies and procedures, any form of privacy or risk assessments that you carry out, and your records of processing along with your lawful basis for processing. So having a privacy governance framework will also help you meet the accountability principle of GDPR.
I hope that's clearer. You're going to need to complete those privacy impact state assessments that Iain has alluded to multiple times, and be ready to demonstrate that you're compliant. So it's not terrifying, but that you can't ignore it. I think is the kind of sort of summary of the presentation, right?
Well, it depends what your definition of terrifying is, but yeah, you can't ignore it.
No, indeed. So I'm just going to run through a final poll, which I'm just launching now, because we'd like to understand if we answered some of your questions during this particular presentation. Hopefully we did. If we didn't, then we'd like to know that too. So if you wouldn't mind just completing that poll, that would be absolutely fantastic. While that's going on, as I said at the beginning, we've had over 480 people on this webinar, so we're not in a position to answer questions. However, please type them in. Iain and I will review them, and we'll write back to everybody, anonymising them, of course, and give you the answers to those questions as best we possibly can. And that concludes the presentation. I'm really pleased to say as well, I don't know if you guys are just being kind, but 69% of you say you're more confident about GDPR since the presentation. So thank you. that makes us feel somewhat reassured that we did a good job. So I just want to thank everybody for your time. It is a really complex process. Hopefully when the slide deck comes round, along with the content, then that will give you the opportunity to kind of digest this in more information. But yeah, we're here for any questions, and do contact your account manager to get hold of that data processing agreement. Thanks for your time.
Thank you.